And welcome to this episode of the Atlas Society Asks. We'll get started in 3, 2, 1.
Hello, everybody, and welcome to the 20th episode of the Atlas Society Asks. Today, we are joined by a dear friend. I've known him for about 30 years, Justice Clint Bolick. And the man hardly needs any reputation. I know a lot of you know and admire him, as do I. But before I even get into introducing Clint, I want to remind you, we are actually live on YouTube, and you guys have been a great engaged audience. So you can ask your questions on the live YouTube stream, or if you're joining us via Zoom, I think we have a record number of attendees. You can just type in your questions into the Q&A section, and we'll try to get to as many of them as possible. So please keep them short, and also be mindful that obviously Justice Bolick can't address any issues that are pending before the court or that are, constitutional in nature. So Clint Bolick, Justice Clint Bolick, was appointed to the Arizona Supreme Court in 2016. Justice Bolick co-founded the Institute of Justice back in 1991. That's from when we knew each other. That Institute for Justice is a nonprofit law firm that litigates to limit government power, especially when it comes to property rights, economic liberty, and free speech. Justice Bolick is widely known for his support of school choice. He's written a number of books, including David's Hammer, The Case for an Activist Judiciary, Death Grip, Loosening the Law's Stranglehold on Economic Liberty, and apparently he's got an upcoming book that we're eager to hear about. Clint, welcome again.
Oh, it's great to see you, Jennifer, if only virtually, unfortunately.
Yes, I know. I think we saw each other last in person last year, and my goodness, so much has happened since then. I know you've been keeping awfully busy. Tell us maybe a little bit about this book that you've got coming up.
Well, it's with a wonderful young co-author, Kate Hardiman, and the name of the book is Unshackled. And basically what it does is it explores the idea of how we would create a school system today, starting from scratch with no preconceptions. Would it look anything like the ossified, monopolistic, top-down, bureaucratic, special interest dominated, I could go on, system that we have today? And of course, the answer is no. We have the technology to provide a highly individualized education to every child in America. And unfortunately, we're within the strictures of a system that doesn't enable us to do that.
That is spectacular, because you and I have long been in the trenches in terms of opposing a government monopoly on education. I worked on that when I was Director of Education Policy at the Cato Institute. But it's one thing to be opposed, but it's another thing to re-envision what is possible. So I think once you get that book out, I would love to, first of all, I'd love to have it as the subject of our book club that we have for our students, but also maybe we'll get a special autographed copy over to this year's honoree of our gala, Peter Diamandis, because he really is about, he started the X Prize in part because he said, space flight is too important to leave it solely up to the government, that we need to get the private sector involved. We need to get innovators involved. So I will be looking forward to that.
Well, thank you.
And again, I want to remind you guys, this is an incredible opportunity. So please ask your questions. I get to start out with a question that I usually, sort of save it to the end, or I don't even get to ask it because, not everybody that we have on the show are that familiar with Ayn Rand or objectivists necessarily. But Clint was influenced by Atlas Shrugged. So tell us your origin story, if you will. You know, how old were you when you read it? How did you get introduced to it? And how does it, you know, influence your work throughout your career and today?
Well, I was fortunate enough to encounter it in college. And like so many college students, I was just a bundle of contradictions. And reading the book really helped me sort out my views, my values. Not only did it lead me to challenge my own internal contradictions, but it also convinced me that some of the things that I thought were contradictions were not contradictions, that there was an overarching philosophy, a philosophy of freedom, of individual liberty that really pulled them all together. And so it was an incredibly influential book. I went on to offer each of my 4 kids $250 as teens if they would read it. So far, 2 of the 4 have taken me up on it, and I'm very, very proud of them. But, you know, I suspect that many of your viewers who have read Atlas Shrugged find it, even though it was written the very same year I was born, it is more and more relevant with every year that passes. Ayn Rand was incredibly prescient. And, you know, in the book, obviously, the government is operating under emergency decree. We never quite find out where it came from, why it started, but it seems of an infinite duration. And here we are in a series of emergency decrees at the local level, the national level, internationally. And I find myself wondering sometimes about these powers. And Rand was so far ahead of her time in imagining this and imagining some of the things that could happen in that sort of situation if we are not bound by the rule of law and some very, very basic core principles.
Yes, and she celebrated, you know, entrepreneurs. And I think that is, you fought for all different kinds of entrepreneurs throughout your career. It's not just, you know, the people that are running railroads. It's the people that are just really trying to get a leg up and start something on their own, but they are being bogged down by licensing laws and by crony capitalism, really. So I think it's a cautionary tale about the limits of government and bureaucracy, but it's also a tribute to the kinds of people that you have fought for all of your life. Someone else who talks about licensing laws and things like that was last week's guest, your friend Christina Sandfer, and she told me something that I didn't know about you. I knew that Christina has, she's an objectivist and that she has a $sign tattooed on her ankle. And then she said, well, you'll have to ask Clint about his tattoo. So is it something that you can show us? And
it is actually something that I can show. I always have thought if you're going to get inked, you may as well do it in a visible way. So when I was working with Christina at the Goldwater Institute, we represented a tattoo studio whose use permit, after they had invested all sorts of money, was taken away at the behest of neighbors that would have preferred to have a Starbucks there. And so we fought for them, and ultimately we prevailed, and they were able to get back to their business. But along the way, when you do these kinds of cases, you get very, very personally involved in your client's plight. Their plight becomes your plight. Their ambition becomes your ambition. I thought to myself, you know what? If we win, I'm going to get inked. So we did win. I did get inked, and after thinking it over, I have typed every book, every brief, every court opinion I've ever typed in my entire career with one finger. my right index finger. So I got a little desert creature, a scorpion with a powerful sting on my index finger. And I have to be careful which finger I raise, right?
Right, right.
But
Might get canceled.
but he's been there for quite some time, and just is symbolic of the David versus Goliath efforts that my colleagues and I over the years have been engaged in.
Well, I love that. I'm not going to get inked, except maybe like eyeliner ink or something. But it would be a hard toss up because we have a lot of scorpions here in Malibu. In fact, when I rebuilt my house after the fires of '07, I call it Scorpies, which is a kind of a tribute to the power of nature. You know, Francis Bacon, nature to be commanded must be obeyed. So I love that. That's adorable. All right, so we are gonna, we have plenty of questions, and I think I could probably anticipate some of them. Obviously, right now, I mean, the news cycle, it's just like, it's totally chaotic, and so much is happening every single day. But there, you know, a lot of what we are dealing with right now is this huge controversy about the nominee. You know, we had this vacancy in the Supreme Court, and a lot of debate about whether or not it should be filled or not filled, and so much, you know, seems to ride on it. I mean, people that are even maybe not supportive of this candidate or that candidate, they don't like him or whatever, they are just kind of very, very focused on the Supreme Court. So why have Supreme Court confirmations become so controversial? Were they always this way?
Well, to an extent, they've always been controversial. Certainly, a number of presidents tried to pack the court with minions that would support their policies, starting with Abraham Lincoln, FDR, Richard Nixon. But really, the reason why they're so important today is because of the breathtaking growth of power in government at every level. And it really falls to the Supreme Court, and this was the role that the framers anticipated for the courts, to hold the other branches of government within their assigned limits. And that need grows constantly, unfortunately. So that's why the stakes are so incredibly high. The other thing that makes the stakes higher than ever before is that lifetime tenure, which the framers in their brilliance bestowed upon the federal judiciary, it really didn't mean all that much when the Constitution was adopted. The average age of a Supreme Court justice was higher than the average age of death. So the moment you would expect that the moment someone was appointed pretty quickly, they would pass away. Today, of course, that is very, very different. Nominees are being appointed at a younger age. They're living to an older age. As a result, the average tenure of a Supreme Court justice is over 30 years. Until recently, with Justice Kennedy, we still had a justice appointed by President Ronald Reagan. This court, every now and then they make a decision that is questionable, but I have to say that this is probably the most pro-free speech court we've ever had in history. It's one of the most pro-private property rights courts, and this court has been steadily reducing the scope of the federal government, at least, moving it back to its constitutionally bounded intention.
I'm really pleased to hear that because you just touched on two topics that we consider so important at the Atlas Society, that we have two upcoming Draw My Lives. One is My Name is Free Speech, and one is My Name is Property. And we are looking at the threats, some of which are legal, some of which are, you know, cultural. But I appreciate that perspective, because you know, it's very easy to get into a complete, you know, everything is going to hell in a handbasket kind of way. But, you know, if you really focus also on too much on the negative, it's what you tend to go towards. So, so that's encouraging. Maybe we'll have you back to talk about that when we launch. But yeah, so more broadly, Clint, tell us a little bit more about why your, what is your jurisprudential philosophy, textualism, and why you had mentioned before that you, in your current role as an Arizona Supreme Court Justice, that you find yourself, you know, in the dissenting minority too often. So what is it about your perspective that, you know, is unique and different from your peers, not even necessarily on the court, but also maybe even within the liberty movement?
Well, actually, I think probably most people within the liberty movement, you know, to the extent they have a judicial philosophy, it is generally textualism, and that is the belief that the court ought to interpret the Constitution and statutes according to the words as they were defined at the time of the adoption. And this is in stark contrast with the philosophy of a living Constitution. Of course, our Constitution is living, but the adherents of that view believe that the Constitution changes with the times, it changes with realities. And we had a period in American history where the court was dramatically expanding the power of government because it thought it was necessary to have those broader government powers, starting in the New Deal, going through the Great Society, and so forth. Ours is a constitution of liberty. It's a constitution of defined and limited government powers. And so a judge who believes in a textualist philosophy will often find that the Constitution protects individual rights and constrains government power. Less so when you're interpreting statutes, because statutes often by their nature are exercises of government power. That sometimes leads judges to results that they don't particularly agree with. Justice Gorsuch, who is a very, very serious textualist, said at his confirmation hearings that a judge who agrees with all of his or her decisions is probably not a very good judge. But nonetheless, textualists view the Constitution as a contract. It is the people giving up a certain measure of their rights in return for the benefits that government can provide. And just like any contract, it should be enforced according to its terms, according to the intentions of those who put it together. And anything beyond that makes the judiciary either a part of the legislative branch or the executive branch, and that is a recipe for tyranny.
So we're going to get to some of our audience questions, and we have a lot of time. So everyone, please ask your questions on YouTube and in Zoom, and we will get to them. Some of you, though, might not be aware of an article that George Will wrote about a recent opinion that Justice Bolick authored, a portion of which was critical of the presumption of constitutionality. Can you tell us how this presumption is detrimental?
So basically, anytime someone goes to court and challenges a law, challenges a regulation or an exercise of government authority, the courts begin with a presumption that that exercise of government power is constitutional. And that is very, very deeply embedded in our American jurisprudence. Just because something is a well-established idea does not necessarily mean that it's a good idea. And in fact, the Arizona Constitution begins with the words, that a frequent recurrence to principles is necessary for the endurance of freedom. And I'm paraphrasing there, but in any event, looking at this presumption of constitutionality, I concluded that this really creates an unlevel playing field for people who go to court to challenge laws, that there should be no presumption of constitutionality. And so in an opinion that did strike down a law that made gang membership punishable separately from a crime that was committed by a gang member, I wrote that we should no longer indulge in the presumption of constitutionality. I think that it's the first opinion articulating that view. It was joined by one of my colleagues, and I've been really gratified by the response from the Bolick conspiracy and and George Will and others. So hopefully this will spark some thought, and perhaps courts will begin to reassess whether we should begin a case against the government with a finger on the scales of justice.
So you mentioned some words, a paraphrase from the preamble to the Constitution of your state of Arizona. Why we were so focused, as we mentioned before, on the Supreme Court? It's like the only thing we seem to be focused on. Why do you think that state constitutions are important, and also how much do they really differ from each other?
Well, they differ greatly. And one thing that they have in common is that every single state constitution contains greater protections of individual rights and greater constraints on government power than does the national constitution. And as state courts, we are free to interpret our own constitutions to provide greater protection of liberty than the national constitution is held to provide, but not less. I call it a one-way ratchet, or a freedom ratchet, because courts in the states can only protect greater liberty, not less. And these constitutions are chock full of provisions that freedom lovers would absolutely adore. For example, the national constitution does not have a privacy guarantee. Most state constitutions do. Many state constitutions include a provision that prohibits gifts of public funds by subsidy or otherwise to private individuals, corporations, or associations. You mentioned corporate welfare before. They were designed to prevent that. I could literally go on and on. Anti-monopoly clauses that are directed not at private corporations, but at the government. And these provisions are available to the citizens to protect their rights, especially now that we're divided into red and blue America. This is a really important facet of federalism, where individual courts and individual states can provide liberties that, whether in the sphere of gun ownership or even abortion rights, depending on your own philosophy regarding those particular types of rights, they can go in their own direction, again, so long as they provide greater freedom rather than less.
So we got one surprise from you in this interview, which was your scorpion tattoo. And in preparing for the interview, I learned there was another surprise, which hopefully, get some people angry, and we have to do that because, like, if we're not getting some people angry at the Atlas Society, we're not doing a good enough job. So you sued Donald Trump. What? Explain yourself.
So a lot of your viewers will be familiar with the concept of eminent domain, where the government can take private property with just compensation for a public use to build roads, to build schools, hospitals, and so forth. Well, in the 1990s, a casino developer in my home state of New Jersey, Donald J. Trump, decided that he needed to build a parking lot for his limousines adjacent to his casino. And the property owners, which consisted of an elderly widow named Vera Coking, who wanted to live out her life in the house that she owned, a little gold and silver shop, and an Italian restaurant called Sabatini's, they didn't want to sell. And, you know, anyone from New Jersey knows how seriously we take our Italian restaurants. So this was a pretty significant dispute. Trump said, listen, it's fine. You don't want to sell to me. I will go to the city of Atlantic City and they will use their eminent domain powers to take the property and sell it to me. And that's exactly what Atlantic City attempted to do, saying that the public purpose is what's good for casinos is good for Atlantic City. And so my colleagues then at the Institute for Justice and I filed a legal action to prevent Donald Trump. This is the backdrop to one of the most infamous cases in US constitutional history, the Kelo case, in which the US Supreme Court held that eminent domain could be used to benefit a private corporation. There, an entire working class neighborhood was bulldozed. And the US Supreme Court upheld that, saying, you know, the words of the Constitution are public use, but we really think it means public benefit. And so long as there's a public benefit, we're going to let you do that. But in New Jersey, the New Jersey courts, applying their own constitution, said, this is not going to work. This is not a public use. We're not going to let Donald Trump take this property. And so Mrs. Coking got to live the rest of her life in her home. And Sabatini's continued selling phenomenal Italian dinners for many, many years. And Donald Trump had a happy ending as well. He got elected president of the United States.
Well, that answers another big question that I had, which is why you haven't yet been nominated to the Court of the United States.
Well, I'm sure there are many reasons for that, but suing Donald Trump is probably one of them.
Yeah, didn't help much. Okay, so speaking of some of your decisions, we've got a question here from Richard Morris, and you might not be able to speak to all of this. He says, in state versus Arevalo, your concurring opinion at paragraph 30. Wow, there's some serious Clint Bolick followers here. You wrote something that he has been advocating since law school in the mid-1960s. You said that a law that diminishes liberty is unconstitutional. The scales are tipped by the presumption of constitutionality. This is a monumental change. How do you see that playing out?
Well, and Jennifer, that's exactly the case that I was talking about a few minutes ago. State versus Arevalo. And the way I hope it plays out, and I really appreciate the question, by the way, is that it will introduce some foment that when litigants go to court challenging government power as unconstitutional, that they'll cite that decision and cite the sources that I cited for that decision and begin the conversation about whether we really ought to have an unbalanced set of scales of justice when it comes to individuals challenging unconstitutional government power.
Okay, great. We have a question here from Vicky. If I can essentially paraphrase what she's asking, the Atlas Society works a lot with colleges and high schools, and the students that are involved with us are really feeling very alienated and kind of under indoctrination and attack from their professors in the humanities. And so she wants to know, is that different in the law schools? I mean, is there the same amount of bias, that we tend to see in undergraduate? Is that an issue also in law schools?
Just as it depends on the particular undergraduate institution, it depends in law schools as well. My son, who is a fan of the Atlas Society, is at ASU, Arizona State University. They've got a fantastic reputation for civil discourse. The University of Chicago has attracted a lot of attention for putting forth principles of free speech and really holding to them. Other colleges, not so much. And you can get in serious trouble for expressing the wrong views. And how sad that is. There's a concept in First Amendment law, the chilling effect. It's not necessarily suppressing speech, but making speech so unwelcome that you simply don't say what's on your mind. And that's, I teach a class at ASU Law School. I teach constitutional law, and I encourage my students, I don't care what your view is, please articulate it. That's how you sharpen yourself. Some law schools, I went to the University of California at Davis for law school. It was an extremely hostile law school. Ideologically, I used to joke that you were free to express any viewpoint along the spectrum from Maoist to Trotskyite. But you know what? It made me a much more effective advocate. It made me sharpen and hone my own viewpoints. And by the time I graduated from law school, I was ready to start suing government bureaucrats. In fact, I sued my law school while I was a student.
Oh my God.
So, I think we should just, for those who are in those situations, just use it as a learning experience. The students who all sit around agreeing with each other and mouthing, to use the word that Rand would use, bromides that really have no thought behind them, they are really not being well served by their educational institution, because they'll never be able to develop critical thinking skills. Conservative students, libertarian students, objectivist students, boy, they are getting a real education. And that's there is life after college, there is life after law school. And one thing I should say, to put in a plug for an organization that's just really changed the dynamics, the Federalist Society in law schools, it got started right after I graduated, much to my chagrin. I would have loved to have had it. But the Libertarian, the Federalist Society is basically a debating society within the law schools, but it's a safe place for people to exchange ideas and to argue with each other in free debate. And that is the sort of organization that I think we need to see more of in undergraduate institutions as well.
Absolutely. I was introduced to the Federalist Society by one of my old friends and a colleague from the Bush 41 White House, is C. Boyden Gray, someone you also know very, very well. It's done tremendous work. We should actually have Boyden on this webinar. And I really, what you say resonates with me, but I also think it resonates as well as somebody who grew up in Massachusetts. And it's always interesting to me that some of the kind of strongest, most dedicated, most confident, and fearless libertarians, conservatives, objectivists, they come from Massachusetts or Canada. So it's like, we have Peter Copsis, was our trustee, and Stephen Hicks, of course, and both from Canada, Chip Wilson from Canada. We definitely have an overrepresentation, but it's kind of like the the diamond. You don't get a diamond unless you really are able to endure a lot of pressure, which is also one of the things, we may not have control directly over, what's going on at our university or our law school, but each of us, certainly as objectivists, we have control over the kinds of attitudes that we adopt, which is why, at the Atlas Society in particular, since we were founded by David Kelly, we really believe that debate and dissent is essential, and toleration is just an essential virtue that we need to practice it with people at first that just agree with us on 90%, but then also practice it with people that completely disagree with you on everything. So
yeah, my son Ryan at ASU, he literally goes out of his way if he sees a socialist booth or someone handing out things, he immediately goes up to them and engages them and starts asking them questions. Why do you support socialism? And going on from there, and often finds that most of these people have never had their views challenged. And that harkens back to what I said about my own experience with Atlas Shrugged. What I think most people love most about that book is that it challenges their foundations, and that's exhilarating. It's a part of the maturation process. It's a part of developing your own moral code, and challenging people who hold these views like socialism or communism. I think that's part of our mission in life.
absolutely. All right, we have another question, and I didn't know this. Maybe you can confirm. Brandon says that you at one point ran as a libertarian long ago. Is that true?
Yes, that is absolutely right. When I was in law school, learning how to be a dissenter, it was one of the first years that the Libertarian Party was on the ballot. I ran for the state legislature in California, and I won 7.1% of the vote, which is pretty darn good for a libertarian candidate. That year, the ticket was headed by the great Ed Clark, just a phenomenal advocate for libertarian ideals, and he was called the reasonable radical, which I think we all should be in a certain sense. But it was really great, a great experience. It helped me learn how to articulate and defend my ideas verbally. But beyond that, it also got politics out of my blood. And so I focused thereafter not on the political arena. And I'm very, very thankful that my wife, Shauna, is an elected official. She's a member of the Arizona State Legislature, but I feel much more at home in the legal arena.
Well, so there's a follow-up that Brandon asks, which, given the last part of your answer, you probably will not have an answer to, when you said that people that care about freedom, should they seek office as a Republican or Libertarian today? Brandon, I'd say when you seek office as a Democrat, we need more people in all parties. You might not get very far. You might not get the nomination.
I just think that find your own niche, find what you love and what you're good at. That combination is absolutely unbeatable. And if it's the electoral arena, I would never give someone advice as to which party to run in. My son, I keep referring back to him, but he has an online petition to allow candidates other than the Republicans and Democrats to get into the national debates. So he has one foot in the Republican camp and one foot in the Libertarian camp right now. I've been a political independent since 2003, and I've never felt so liberated by that choice. I never have to defend my party because I don't have one. But that's a deeply intimate decision that people have to make for themselves. And I just hope that everyone listening to this will take their skill set and put it to very good use, even if it means just making millions and millions of dollars and contributing to very effective nonprofits. That's a great way to affect the world as well.
I would totally second that. I have no bias, no ideas, of which nonprofit you should donate to, although I did hear that our chairman is matching all new donations to the Atlas Society this year. So yeah. Okay, so this is more of a general question from Vicky. She wants to know about the issue of legislating from the bench. What are the problems? And maybe even to start, like, that's a phrase we hear thrown around. Like, what does it mean?
So Vicky, thank you for that question. The framers, when they put together an independent judiciary, they said in Federalist number 78 and Marbury versus Madison that we need an independent judiciary to hold the other two branches of government to their assigned boundaries of power. But we have nothing to fear from the judiciary doing that. But we would have everything to fear if ever the judiciary exercised executive powers or legislative powers. And so, for example, when a court decides to strike down a law, that's what it should do. It should strike down the law, and then the legislature gets to decide what's in its place. But so often, and I was teaching in my class the last couple of sessions on Roe versus Wade. Regardless of what you think of the right to an abortion, Roe versus Wade did exactly that, striking down laws restricting abortion, and then went on to write a law of its own, saying that we're going to have a trimester system. And in this first part, the woman's rights are sacrosanct, and in the latter part, the states' rights are sacrosanct, and in the middle, it's kind of amorphous. Same thing with Miranda, the Miranda case, where basically the Supreme Court ruled what police officers had to say, and those are you have forced busing for integration. You had courts creating racial quotas. On and on, the list can go on, and that's not the role of courts. And when the courts get into that arena, they really politicize the branch. No one votes for federal judges, and it's a horrible violation of the separation of powers and results in an erosion of liberty rather than protecting the rights, which is the assignment of the judicial branch.
All right, well, I think we have time for maybe 2 more questions. And we've got a question here from Fossilized Dodo. And Fossilized Dodo, you get the prize for the weirdest screen name, which in my book, by the way, is a compliment because I'm a big weirdo and I like weirdos. And this is actually kind of speaks to the point that Justice Bolick was just making. He says, how much power should the states have over their localities? So kind of like the federal powers over the states. Could you say that sometimes there are scenarios where the all-powerful state, I guess he means by that the, state as in this, the various states, where the all-powerful state can crush rights?
Oh, unquestionably. And I'm not sure I totally understand the question. Your first articulation of it made me think of the relationship between state governments and local governments. And to the extent that that's the question that's being asked, the states are the organic units of government in our society. Local governments are creatures of the state. And of course, both of them are subject to the US Constitution and the states subject to the state constitutions as well. I've written extensively over the years about the phenomenon of grassroots tyranny, where local governments, which really regulate the most intimate details of our lives, from where our kids go to school to what our streets and neighborhoods look like, et cetera, our police departments. We pay so much attention to national elections and almost none to local elections, and holding local officials to the limits of their power. So I apologize if I've misfired on this question, but I think that we need to be alert, and our Constitution is alert to deprivations of liberty by government, no matter what level of government.
All right, we're going to take this last question, which is kind of an open-ended question from Greg Dulgoff, who says, I cannot be born and stay on land and never leave and grow my own food. There is no freedom. I cannot stay on land unless I pay taxes. Yeah, he's just kind of saying that he feels like there is no freedom. And it also speaks to an interesting question that comes up time to time within the liberty movement about taxes. And, we have libertarians who say taxation is theft. And of course, the federal income tax is a relatively new imposition. But Ayn Rand, for one, she envisioned a system of voluntary taxation, but she was not an anarchist. So I clearly on one extreme right now with sort of unlimited taxation. But do you have a perspective on that? Because I know it's not really a total focus of yours.
Yeah, I guess two reactions to that. One is that state constitutions do have limits on taxation. Your own state passed, I think it was Prop 209 years ago, that limits property taxation. It's interesting, basically, as the states put their own constitutions together, and especially as our country moved west, they sought to improve upon the national constitution. There are no structural limits to taxation or few structural limitations on taxation in the national constitution, but many states do have them. The other is the right to travel. And we are living in a federalist era right now, where we have marijuana federalism, we have abortion federalism, we have COVID federalism. We have states engaging in very, very different sets of policies. And one of the most essential rights that we have as Americans is to vote with our feet. I think Doug was talking about going to sea. Hopefully we don't have to do that, that we'll be able to preserve our basic freedoms right here in the United States. But I can see every day new California license plates in my state of Arizona, and people are voting with their wheels in that case to leave one state for a state that they think offers a brighter future.
Well, I know that is a fact. This year alone, I think we've had 3 donors who've left California for Arizona, 2 who've left for Texas, and 2 who've left for Gulch in Colorado. So, but just as in Venezuela, we just released My Name is Venezuela. My Spanish teacher is in Venezuela, and all of his family is in the diaspora in other countries. You're going to need one person to stay behind and go down with the ship. So I, at the moment, am volunteering for that. But otherwise, I will be there in Arizona. And I hope all of you, first of all, join me in thanking Justice Bolick for taking this time out of his extremely busy schedule as a justice and as a teacher and as a dad and as a husband and as an author of a new book. But I hope to see Clint again soon, IRL, in real life. And I hope to see a lot of you guys at the gala. It's a week away in Malibu, in California. It's going to be just beautiful. And then also we'll have a virtual component. So I'd love to see you there. And Clint, so wonderful to see you and learn. I can't believe after all these years, still learning things about you.
It's been great to be with you, Jennifer. Thanks to those who have joined us today and for the great questions as well.
Thank you. Okay, we'll see you guys later. Take care. Thanks, Clint. Bye.
Thank you.